Hello everyone. In this lecture, let us discuss about some really important case laws which have actually changed the entire Muslim jurisprudence in India. There are some cases which are so remarkable, have so many controversies and subsequent legislations because of these, and they are very important even for the exam perspective. Our actual journey on this starts in the year 1985. In the year 1985, there is one really important case that has happened. The name of the case is Shah Bano versus Union of India. In this case, Shah Bano was just a normal Muslim lady. She was illiterate, she was dependent on her husband, and suddenly her talaq happened. She got divorced. As per Muslim law, Muslim customary law, she would get only if she had meher left. And in this case, she got very little money. And it was only during the iddat period that she was taken care of, and so basically what happened, she ended up having no financial resources. Then she goes to court. Shah Bano goes to court and says, judges, please listen, you have made one law called CRPC. Yes, CRPC you are saying is applicable to everybody. Yes, irrespective of what religion you belong to, CRPC is neutral, secular law. Everybody it is applicable to. In CRPC, there is one rule, section 125. Under section 125 of CRPC, women can get maintenance for the rest of their life till the time they are alive from their husband if they are unable to have their own livelihood, unable to have their own independent source. This lady goes and says, if you are saying section 125 CRPC is applicable to all people, then it should be applicable to Muslim women also. So I am a Muslim woman and now my husband is not giving me any money. I have no money. I am uneducated. She's quite old also by the time this case happened. So please give me money. And Supreme Court says, yes, whatever your points you have raised are actually correct, because section 125, it says financial assistance, financial support shall be given to any woman. Right? Divorced women, separated women for the rest of her life. And this is applicable to everybody. So even Muslim women should get this. That's what they say. That is what Supreme Court said finally. Now this caused so much controversy because the Muslim males were not happy at all. They have multiple reasons. They said, as per customary law, we will provide whatever meher is left for her, dower is left, we will give that. That is the customary law. Then under customary law, during iddat period, meaning for 3 months, we will take care of her. That is only what is given in the customary law. But through this judgment, Supreme Court is telling us to do things which are not part of customary law. So a lot of controversy happened. A lot of people said this is going to take, and in Muslim law, it's not one wife, it is 4 wives. So they are saying that how many people will we take care of? To put an end to all of this, what the legislature did is it brought a new act. What is the name of the act? One long act, Muslim Women Protection of Rights on Divorce Act 1986. Ma'am, too lengthy? Yes. What should I remember, ma'am? Shortcut for this entire thing, shortcut is Muslim Divorce Act 1986. But sometimes in the exams, even this full name is asked. So you should be aware of the full name also. Okay. Actually, it was in this context in 1985, 86. It was in this context when a lot of controversies are happening. A lot of people suggested that in India, there should be uniform civil code, meaning there should be one civil code in which all the women, irrespective of whatever is their religion, will get equal right. Basic equal rights should be provided for everybody. Of course, even today, we still don't have a uniform civil code at a national level. And so, it didn't happen now. How would it happen then? So, in 1986, instead of actually going for a uniform civil code, the government says, listen, we have listened to you. We have listened to the Muslim community. And they brought this act. And in this act, what they did, they actually reduced the judgment effect. Judgment actually gave a lot of power to the women, because irrespective of religion, you can now go and get maintenance. This act reduced the right. This act says If both wife and husband agree, then only you can go for section 125 maintenance. Now you tell me which husband will agree to give maintenance for the rest of their life under section 125. So this was argued that it is not a practical suggestion, but that is part of the act. Section 5 of the act, section 5 of 1986 act says, yes, section 125 CRPC is applicable, but for that to be applicable, husband and wife both should agree. Then only section 125 will be applicable. Otherwise, what is applicable? Customary law will be applicable. Under customary law, she will only get for 3 months, only during her iddat period. Husband will take care of the financial need. If she wants, after iddat period, she can get remarried, then no problem. But if she is not remarried, even then the first husband will not take care of her. Similarly, they say if it is children are involved, okay, up to 2 years of age for the children, we will take care. So in that context, if you see, this is a very narrow act, because in Hindus, if you see, for example, Hindu Adoption and Maintenance Act or Hindu Marriage Act, provisions are made for at least till majority, till the child becomes 18 years of age. If it is a girl child, till the time she is married, provisions are made. They can be made by the judge. But however, in 1986 Act, it has reduced the scope really, and restrictions are there on the wife maintenance, on children maintenance also. Now, when such controversial laws happen, they will have to be challenged in courts. So what happened? 1986 Act got challenged in courts. That is the case of Daniel Latifi versus Union of India. In this case, this 1986 Act was challenged, but Supreme Court upheld this Act. Why did they uphold the Act? Because honestly speaking, 1986 Act included only those things which are part of customary law. And religion is a very personal matter. Whatever is being accepted by the community as personal law cannot be interfered randomly by the judges or by the parliament, right? So that's the reasoning, and they said this is valid only. And they also say, in case the wife is unable to maintain herself, she is unable to remarry, she is dependent on somebody, she can take help from relatives. The relatives are obliged to take care of her. But if it is a case where relatives are also not taking care of her, we have something called the state Waqf boards. These are nothing but welfare organization, welfare trust made specifically to take care of Muslims. So they say we have the state Waqf boards. The Waqf boards will take care of such women who are unable to take care of themselves, who do not have anybody else, any of the relatives to take care of them. From the husband, they did not get sufficient money. In all such cases, they say there is something called a state Waqf board, especially for Muslim welfare. These Waqf boards will take care of it. Okay. So here ends the discussion on Muslim maintenance of women. After this, there is another issue and some other interesting case laws that have happened from it. Sarla Mudgal case actually came because of misuse by some men of the 4-wife policy under Islam. So what used to happen? Some men, Hindu men, they first got married long time ago under Hindu religion to some lady, first wife. While the first wife is still alive, after a couple of years, they decide now they want second wife. What these people started doing, even some celebrities did this, they converted from Hinduism to Islam and then married the second wife and said, now that I am Muslim and Muslims can have 4 wives, I can have second wife. Now this started happening, lot of misuse was happening. So people said that this is actually fraud. How can you do this? If you want to convert, you have to convert for religious reasons, not because you will take some loophole and use it to your benefit. In this context came the Sarla Mudgal case. In this case also, once again, everybody started saying we should have uniform civil code in India so that there are no loopholes that one religion has something, other religion does not have these rights, so I will misuse these rights. This sort of thing won't happen. So finally, ma'am, what happened? The Supreme Court said this is absolutely wrong. We cannot allow you to take such loopholes, use such loopholes to your advantage. This entire process of marrying, it's illegal. If you want to convert, you have the right to convert from Hinduism to Islam. Your wish. If you really want to convert, you're an adult, you can give up Hinduism and convert to Islam. No problem on that. But if you are converting and then you want to marry, first you give divorce to first wife. First wife, you got married under Hindu law. You give divorce to first wife under Hindu law first. After you give that divorce, then you convert and then you marry 4 wives in Islam. No problem. Right? This is what they said. They said conversion, if you want, you do. But this concept of I will keep first wife also, I will keep second wife also, this cannot happen. You divorce the first wife, then you can have how many ever wives you want. Okay, that was the case of Sarla Mudgal. Important. These are all Supreme Court cases only. Okay. Next, this is relatively recent. Shamim Ara case. You don't have to know much about it, but what actually happened you should know. Finally, about talaq, there is something written down neatly in this judgment. Because again, customary law, nothing is clearly written, guidelines, rules, procedures. This is not written down clearly. Finally, after looking at a lot of customary law, religious texts, in this case, they have laid down guidelines, they have laid down conditions saying that even as per customary law, customary Muslim law, there are certain conditions that every Muslim husband should follow. After following those conditions only, talaq can be given. So this is a case that talks about talaq, how it should be given, what are the guidelines to give proper talaq. All of this was discussed. Okay. Then we have the last case of Shaira Banu versus Union of India. This judgment we have already discussed in a lot more detail earlier. This deals with triple talaq case, meaning talaq, talaq, talaq 3 times once in the same sentence. If a husband says, then the talaq becomes final. This is called as what? Talaq ul biddat. This is a type of talaq, talaq ul biddat, and we said biddat meaning bad. That's how we remembered it. Talaq ul biddat is bad. It is unconstitutional in India. So these judgments about some divorces, about right to marry, about Muslim maintenance, these have all been landmark in understanding how the old customary law is still to be applied in Indian context today.